final keynote of today will discuss how technology has simplified the process of making complex legal messages more understandable through what is known as legal design and also with the help of AI. We'll also get some real-life examples of what this process and what this approach looks like in practice. As usual, we will use the event app for questions, so keep them coming. Our keynote speaker is Helena Haapio. She's a contract strategist at Lexpert and associate professor of business law at the University of Vaasa in Finland. And she's also a professor of practice and docent of proactive law and contract design at the University of Lapland. Please help me in welcoming Helena Haapio. Welcome.
Thank you.
I'll leave the floor to you, Helena, and then we have some questions coming from our audience, so the clock will show your time, and then I will take a little bit of that.
Okay, great. Thank you all for coming, and good afternoon from my side as well. Now, my topic is related to tech, but I'm rubbish when it comes to technology. I'm curious, but I won this award not because of my tech skills, but because I do what I do, namely proactive legal thinking and design. And I invited an uninvited speaker, if I may, because proactive law may not be familiar to all of you, so he helps me make the distinction between proactive law and conventional law. He's conventional. He litigates, and he speaks fluent American English. He says, "This is an outrage." And he says, "My client is innocent." Okay, then he says, "I'll see you in court." And that's what he's famous for. And he is the famous kind of lawyer. In media shows and television and everywhere you see lawyers fighting about winning. And well, not fighting about losing, but somebody needs to lose. So this is not proactive preventive law. But this tends to be the mainstream still of what law is when taught at law school. It's looking back at frozen facts and resolving disputes, rather than preventing the need to litigate or using legal skills to promote what is desirable. And that's more of the kind of proactive law which we practice. I'm going to say a few words about what's wrong. I'm sure you all know that there's plenty of things that are wrong. And this is one example. Is this really what we want? This is a student tenancy agreement. Probably the first agreement a student will make in their life, and they are supposed to find out what to do and what not to do. Now, it's not humanly readable, is it? Even for an adult or for a lawyer. Contracts are not the only example, of course. Tenancies, leases, these things. We sign things all the time like this. Terms and conditions, privacy policies, we just click, I agree. But do we really need to read them? I don't think anyone in their sound mind really does read them. Why do we lawyers write them then? Are we just pretending to communicate? L to L. I borrowed that concept from Chris Simpkins, who is working in the UK. And he writes about lawyer-to-lawyer communication and how we need to get rid of lawyer-to-lawyer only communication. Then I added L to N, lawyer to no one, because that seems to be the case for the most part, with the small print, lawyer to nobody. This problem, of course, has many names. It has been called too long, didn't read, wall of text, fine print, legalese, information scattered around, so no one really cares to read or find what they need. This leads to unnecessary information overload. Readers give up, and the lawyers writing L to L or L to N really do pointless work. No one benefits. Readers' problems often become writers' problems. I used to work as an in-house counsel with engineers, shipbuilding, diesel engines, heavy metal, that sort of thing. And they would turn to me, even though the answer would have been in the contract, but they wouldn't want to read the contract. So there's something wrong with contracts as usual. Inadvertent non-compliance occurs if people don't read. And also opportunities are missed. People keep asking us experts the same questions repeatedly. And readers and non-readers' problems become writers' problems. Unnecessary problems, risks, and so on. So we need better communication in contracts and elsewhere, communication that works for humans. And writers need help to produce such documents and communication. Now, I was so pleased to find that the EU has come out with the Declaration on Digital Rights, which talks about putting people at the center. And I went to look at it and I found beautiful things about empowering people and all things nice. And then I looked up the thing itself, the declaration. Now, is this really the way we can put people in the center? It doesn't even tell us how to do it. And then the way it looks is really off-putting for most people. This is what we see. It just all looks the same. There's got to be a better way. And that's where our story really started, merging proactive law with information design and technology to solve the problem and prevent it from reoccurring. One major source of really inspiration for me has been simplicity, contract simplification, legal simplification, the ultimate sophistication attributed to Leonardo da Vinci and others. Lou Brown, known as the father of preventive law, he said that it usually costs less to avoid getting into trouble than to pay for getting out of trouble in the 1950s. And we started to build on his thoughts, Lou Brown's thoughts. He borrowed them mainly from preventive medicine, branch of medicine dealing with the prevention of disease. So he wanted to prevent the disease of litigation and provide clarity about rights and duties, help people stay in better legal health. What we did, and this is 2005, a conference Cecilia Magnusson Sjöberg chaired here in Stockholm, one of the first proactive law conferences. We added to the preventive dimension a promotive dimension, where we want to promote what is desirable and prevent what is not. We have this book out. It's on the internet if you're interested. All these resources accessible. And it's not just us. It really seems that we lawyers are finally getting more like engineers and copying good ideas from engineers. We also want to make something useful that works for our clients, which makes us learn from engineers and designers. I was fortunate to get to learn a few information designers early on. With them, we have been experimenting with companies' real documents, contracts included. And Stefania She wrote an empirical PhD at Aalto University. I did mine at Vaasa. Mine is conceptual, next generation contracts. Together, we have been working on projects where we have humanized communication. Here's one example that Stefania did. She took that tenancy agreement and turned it into a user guide kind of bullet-pointed thing, and then tested it with the students, the real users. And guess which one was giving better answers faster and a better user experience? Of course, the one on the right. And then slowly we did legal design jams, hackathon type of things in Greece and at Stanford and various places where we took something complicated like the Wikimedia trademark policy and added an executive summary or icons or ways to simplify those complex messages. Here's the Legal Design Alliance that we founded some 5-6 years ago. If you're interested, the Alliance has resources where we call for cross-professional collaboration around making the legal system more understandable, more proactive, promoting what we want and preventing what we don't want. We've written books about the topic, and then Stefania and I, 2016, started to collect patterns, design patterns that work. And we put them into a library. This is an open access free resource. If you're interested, it's on contract design patterns, but we are told that these patterns work elsewhere as well. So please go and have a look. We have 10 pattern families available there right now. Some patterns also around privacy communication. One of the early examples, the juror privacy policy, looked like anyone else's privacy policy, but then Stefania and Juro worked together and built a summary and timelines and used design patterns to communicate the message so that people would actually read it. And it was so copied and so much happened around it that they decided to make it openly accessible, and it is. So the template is shared. You can go on GitHub and use it. You have to populate it with your own content, of course, but these things really can be shared and we can learn from others' work. Information designers work with content, structure, language, and design, and can often work together with plain language experts. Plain language is not just about language or wording, it's also about design and structure, so that users, readers, intended readers can find what they need, understand what they find, and then use it. So this is something where you can guess it, ChatGPT can be helpful. A lot of manual work has been avoided since November last year when we started to get first drafts created by ChatGPT. This is where I have been using ChatGPT so far. Various different experiments. If you're interested, I have a little handout that I can send you showing how I've been using it. Then I only have one example here, and that's where I said, ChatGPT, surely you can't do that. I was actually told by my pocket lawyer friend to question this, and of course, it can create great suggestions and first drafts of content, summaries, in Swedish, in Finnish, in English, and translated, and then headings, explanations, all those things that took so long for us to create layered layouts. Now we have the first draft in almost seconds. Here's just one example where ChatGPT explained the NDA and then suggested headings, and then different readers can find different kinds of information, like in Creative Commons licenses, for example. You have different layers for different readers. It's so much easier to make information understandable now than it was 10 years ago. Now we have the design patterns and we have technology to automate them. So nothing should really stop us from doing it. Here's an example of an event that is coming, proactive law, proactive contracting in December. There's a call for papers out for those of you who are interested. There's an AI section built in there. And my key takeaways for this session would be that we really need to get away from L to L and L to N communication. And we can. It isn't that difficult anymore. We can humanize communication so that we can better collaborate with other professions, reach consumers, reach readers, and even non-readers. Support our goals as drafters, as designers, to provide clarity, to encourage and enable performance, value creation, these things that we desire so that parties reach their goals in contracting and avoid unnecessary problems, so we can promote collaboration and prevent the causes of conflict. To get back to the today's topic. And we can guide all readers, not just judges or arbitrators, but people in the field, and help them comply. And I'd like to conclude by citing Margaret Mead, who said, "Never doubt that a small group of thoughtful, committed people can change the world. Indeed, it is the only thing that ever has."
Thank you so much. I think this is so interesting because it seems so straightforward, and still there are so many people and entities that would like to keep the old system because there's a lot of money in being complicated and vague and hard to understand. But we won't talk about that now. We will talk about some questions from our users. One is it possible to create sort of a legal icon of a contract in the same way we in Sweden have a stamp for ecological marked food? So that I think the question is, can we have some kind of icon that shows that this contract is designed in a way so that it's easy to understand and easy to act upon?
Yes, we can, and there's actually attempts to do so. There's one by World CC, the World Contracting and Commerce Organization. It's currently called Better Contracts. It doesn't say perfect contracts or even good or great contracts, it says better.
And is that sort of an open source stamp?
It is a stamp that you can gain if you fulfill certain conditions, and those are transparent and you can look them up. So if you're a company and you want this label, then I would encourage you to go and have a look.
Another question is on the theme of how to change things. Do you think making legal jargon more readable will be a hard change management journey? Because some people and companies prefer to hide behind a wall of text because they will get less challenges from the end reader.
Yes, we need change management, and we need design skills as change skills and also engineering skills. So it's so much easier to copy paste and do things as they were done before than go and check and change something or take away something. That takes so much courage. But I would still encourage everyone to go and have a look at their terms and conditions and contracts and policies and ask, is this really what we want? And do we really need all this? And has anyone read through this for ages?
You've practiced law, and I'd like to understand how the process of creating a contract or a framework, say, for AI, any kind of text, where do you start or how does the creation of such a text or contract change when you are working with design principles and with a user experience in focus?
I would say that this new kind of contracting is a team sport. So I don't think anyone can do it alone. No one person knows the content well enough, and then the scope of work and whatever the appendices need to say and should say. And then there's the business side, and then there's the user side, and then there's the legal side. So the legal part is a contributor, but not the center of the universe in this.
So human-centric, reader, user in the middle, and then supported by people who know the industry or know the...
Ideally, yes. It would be often better to start from scratch and ask, what is it that we really want to communicate? What is it that we really want to achieve? Rather than begin from a complex text and start to simplify it. But both are possible and both are good to take the initiative to do.
So another example where collaboration really is the winning way of working. If we look at conflict, which is another theme of today, is there any risk of, say, oversimplification or making it less precise when you work with legal design?
The question often comes whether we want precision or whether we want something that functions for the people in the field. And legal precision is a good and understandable goal, but if the people in the field then cannot read or perform in accordance with that precise contract, then it is not a good contract, I would say. So we need to find a balance and sometimes take a risk and just care and dare to be the first one. The first adopters of visual contracts, for example, Shell, Airbus, then there's comic contracts by Robert De Roy, so there's courageous people who have already taken the step to change things. And I haven't heard of any really major risks around those contracts, quite the opposite.
I'm checking, we have lots of questions here, but we do have time. How do these texts work in court is another question.
That we should ask him rather than a proactive preventive lawyer. But the courts about contracts, they want to enforce the will of the parties, and they look for what is it that the parties wanted. And if the parties wanted what the drawing says or what the timeline says, and if that clarifies the intent, then I think the picture is better than 1,000 words. If those words are not clear for the parties, if they don't express the will of the parties, and if it isn't implemented as desired.
There is another one here. Do you see any risks using ChatGPT to simplify complex legal texts? I don't think you said actually that you will only use it, but you said to draft, right?
I would encourage you to send me an email message. I'm happy to send you my checklist. I see risks, but I see even more opportunities. So yes, there are both. But I am definitely a believer in technology helping us do a better job as lawyers, even and drafters.
And here's a great question. The main focus of your work has been contracts. Are these tools or principles available to land regulation, for example, data and AI to R&D teams?
Oh, yes.
So there are general principles for how to communicate complex content into a readable and understandable form.
Absolutely. I think we borrowed them from architects or software engineers, the idea of patterns or design patterns. So definitely everyone with their own content can do a better job organizing it. And sometimes it seems to me that it's not just L to L, lawyer to lawyer, but it's sometimes also E to E, engineer to engineer, where we just don't cross-talk or even maybe don't want to do so, but as we have seen today and we'll see tomorrow, we should, and we will all be stronger together.
What are the main obstacles? There are several questions here about obstacles or what's blocking us for embracing this type of human-to-human way of communicating. Or the other one was what are the biggest obstacles when trying to simplify contracts?
Mindsets, probably, and then old templates. A colleague said, Verity White from Australia said that old templates are really the ocean plastic of the contracting world. So there's so much around of this old stuff that we all get accustomed and think that that's the way things are. But when we change mindsets, and we can change mindsets with new design, so that works both ways and can open a, well, better circle or virtuous circle.
I think that's a classic, isn't it? That templates are the ocean plastic of contracts. One last question: if you were granted a big bag of money and you could spend a few months researching a new area in your field, what do we need to understand even more about in the area of legal design?
I would put that money into collaboration with business people, engineers, lawyers, medical experts, depending on the context, and then work for sustainable, responsible AI, sustainable, responsible ESG research, where we could all bring our skills to the table for a better world.
I'll do the simplistic test because I know you're curious. Was this valuable, clear, and understandable for you, Helena Haapio's presentation? Hands up. So
wonderful.
You're working like you're teaching. Thank you so much for joining us today.